Okay, we're going to talk now about expression, specifically speech, and we're going to have some cases that go along with that. The first case is going to be Schenck versus United States. In the case of Schenck versus United States, the Supreme Court ruled that speech that presents a clear and present danger can be prohibited. So, as was probably talked about earlier, you have no absolute right to anything. So while the Bill of Rights are a list of rights that you have, they are not absolute. So the question then becomes, what are the limits to these things? Well, in the case of speech, speech that presents a clear and present danger can be prohibited. In the opinion in this case, Justice Holmes uses the analogy of yelling fire in a crowded theater. So while you have a right to free speech, you do not have a right to yell fire in a crowded theater because that could cause a panic which would injure people. So what speech presents a clear and present danger? Here are some examples. Fighting words. Fighting words are those words that are uttered in a manner designed to elicit a violent reaction from a reasonable person. So now fighting words are prohibited, but don't confuse fighting words with hate speech. Hate speech, while offensive to most people, is for the most part protected. Those same words used in a different context could be considered fighting words. So just because speech is offensive, in fact, may be offensive to the vast majority of people. It might be racially insensitive, religiously insensitive, could be unpatriotic and so forth. That doesn't necessarily constitute fighting words, okay? In the United States, we do not censor ideas. That's not something that the United States typically does. However, those same words used in a manner to provoke someone to violence, then in that context, it could be prohibited under the doctrine of fighting words. Other speech is not protected. Conspiracy, whenever you plan to commit a crime, that speech is not protected. Sedition, which would be encouraging the violent overthrow of the government of the United States. So there are different types of speech that is not necessarily protected. Simply disapproving of a policy, disapproving of a government official, that is protected. Okay. Next thing is symbolic speech. Symbolic speech is communicating with other individuals through the use of symbols, such as Democratic donkey, Republican elephant. Imagine those in the form of a bumper sticker being put on someone's car. No words are used, but a message is conveyed. The case that we're going to focus on for this course is going to be Tinker versus Des Moines School System, Iowa. And in the Tinker case, the Supreme Court ruled that the utilization of a black armband to express dissatisfaction with the war in Vietnam was a protected form of speech. Now, there's another element to this case that deals with the rights of students in public school, and it's not really that relevant for this course. The focal point of the case for this course is going to be the fact that symbolic speech is protected. There's another case that we don't have on the screen, and that is Texas versus Johnson, which deals with flag burning. Flag burning to protest various government actions, various government policies, and so forth is constitutionally protected. And we'll say that one more time. Burning the American flag as a form of protest is constitutionally protected. So says the U.S. Supreme Court in the case of Texas versus Johnson. Okay, freedom of the press. Here are some cases on freedom of the press. Neer versus Minnesota is whenever the Supreme Court dealt with prior restraint. Prior restraint is the idea that prior restraint is a situation where the government would be prohibiting the publication of something before it is actually published. It is stopping the publication of an idea, a speech, an article, or so forth. In effect, it is censorship. In the case of Neer versus Minnesota, the U.S. Supreme Court said that is not permissible. So while the speech may result in a crime, the article may result in a crime, the article may result in, might be libelous, which could result in a lawsuit, the government still cannot stop the publication of it, generally speaking. After the article is published, then you can take care of any legal action after that. So no prior restraint. There is a narrowly defined exception to this, and that is going to be in the case of national security. For example, if you have the launch codes for nuclear weapons and we're going to publish that, the government could probably stop that publication. Beyond that, simply disapproving of military action or disapproving of a war, that doesn't necessarily threaten national security and would not be able to be prohibited. Miller versus California. In the case of Miller versus California, the U.S. Supreme Court gave us a test to deal with what is obscene and what is not. Pornographic material is constitutionally protected. Obscene material is not. Pornographic material, that is to say, material that is sexually oriented or sexually related, is protected. Obscene material is not protected. So to figure out what is obscene, the Supreme Court gives us a three-part test called the Miller test. The gist of the Miller test is that the work has to violate contemporary community standards. It has to lack serious literary artistic value, and the work has to violate some sort of local law that deals with obscenity. There's a little bit more to it than that, but essentially it's three parts, and that's going to be the way to determine what is and what is not obscene. Okay, next we're going to deal with the right to assemble. The case that you need to be familiar with is National Socialist Party of America versus Village of Skokie. And in this case, you've got a group of American neo-Nazis that want to have a parade or a demonstration in Skokie, Illinois. Skokie is a suburb of Chicago. Skokie has a sizable Jewish population, and at the time of the case, in the 1970s, a sizable portion of individuals who were direct survivors of the Holocaust. So obviously, Nazis parading in Skokie is not going to be too terribly well received by the citizens of the town. So the town goes through various legal permutations to try to stop the assembly. The Supreme Court eventually rules in favor of the Nazi Party, stating that the way you protect free speech and free expression is to give it to as many people as possible. Just because an idea is offensive or just because a group is offensive doesn't necessarily mean that you can prohibit it. Another thing to be mindful of that occurs during that came up during the case of the Skokie, Illinois case is going to be the idea of a heckler's veto. The mere threat of violence cannot be used as an excuse to stop a protest or a demonstration. Because if that is the case, then any time a group that somebody might find offensive, or for that matter, the group that most people wouldn't find offensive, were to protest, all it would take would be for one person or a small number of individuals to threaten violence, and that would be utilized as a way to stop the demonstration. So the mere fact that there might be a violent reaction to the presence of Nazis in Skokie cannot be used as a reason to stop the protest. Okay, now we're going to talk about some limits on free expression. Some of these we've already talked about, but we'll hit them again. The first one is defamation. To defame someone means to speak badly about them, to run down their character, to impugn their motives. There are two types of defamation, libel and slander. Again, neither one of these is going to be constitutionally protected. They're not necessarily illegal, but if someone is libeled or slandered, they can sue the individual who libeled or slandered them. Libel is printed, slander is spoken. For purposes of this course, there's no real difference between the two other than the medium that the message is conveyed. Both are forms of defamation. Defamation is not protected, and therefore a person who has been defamed can seek legal remedy through the court system with the filing of a civil lawsuit. Obscenity is not protected. Therefore, state and local governments, or for that matter, the national government, can pass laws banning obscenity and the distribution of obscene material. If you recall, we have the Miller test to decide what is obscene and what is not obscene. And then finally, governments, both local or all local, state, and national governments, can place limits, reasonable limits, on time, place, and manner of expression. So a group might have a right to have a parade, but they don't have a right to have a parade at 5 o'clock in the afternoon down Main Street because that would affect the flow of traffic. Now, what a government cannot do is pick and choose between who is allowed to protest and who is not. If you're going to allow parades or allow protests in a city park, what have you, you don't get to pick who can and can't. You can have reasonable rules for utilization of parade grounds or city park or whatever, such as no demonstrations at 2 a.m. in the morning, but everybody has an equal opportunity to use the park for protests and so on during normal daylight hours. Again, the government cannot pick and choose which messages will be expressed, but they can impose reasonable rules that relate to the manner of expression and the time and the place of expression. Let's talk briefly about the right to petition. The First Amendment protects the right to petition. The right to petition is effectively your right to complain to the government. It is your ability to tell the government and government officials what you like and what you don't like. And you have a constitutional right to express your opinions to government officials. And by utilization of this right, you cannot be punished or have any other hardship imposed upon you. Second Amendment. Second Amendment deals with the right of citizens to keep and bear arms. There are two basic cases on this one. The first one is District of Columbia versus Heller. In the case of DC versus Heller, the District of Columbia had imposed rather restrictive requirements on the ownership or possession of handguns. In effect, hardly anybody was allowed to own or possess a handgun. And the Supreme Court ruled that these were unconstitutional. Now, it should be noted that the case of DC versus Heller does not incorporate the Second Amendment. In 2008 and 2009, the Second Amendment did not apply to the states. So if a state were to ban weapons, it would not violate the Second Amendment because the Second Amendment had not been incorporated. It was not until 2010, in the case of McDonald versus Chicago, that the Second Amendment is incorporated. Using similar logic in the case of DC versus Heller, the Supreme Court will incorporate the Second Amendment and the standards thereof and require states to comply with it.